Good afternoon. Please be seated. Today we have 1421-00121 New Tech versus Nostein. Everybody ready? All right. I've got 4 minutes reserved for rebuttal. Is that correct? All right. Whenever you're ready.
May it please the court. My name is Byron Keeling. I'm counsel for the appellant New Tech Global Ventures. This is a Tcpa case. At least 3 of the 4 defendants, if not all, never engaged in any Tcpa act of communication. As to the 4th defendant, the evidence raises a prima facie case of legal malpractice. The defendants here have the burden to prove or to establish that the Tcpa applies to New Tech's claims. For any movement to prevail on the Tcpa motion, that movement must show that the plaintiff's claims challenge that movement's exercise of a Tcpa protected act. There are 3 Tcpa protected acts. The defendants here invoke the right of petition, but as to each of the 3 protected acts, they require a communication. Where a plaintiff's claims rest on a mix of protected activity and unprotected activity, it's the defendant's burden to segregate between the protected activity and the unprotected activity. Only claims that are based on protected activity fall within the scope of the Tcpa. This court must review the pleadings holistically under the Texas Supreme Court opinion in Adams, and reviewing New Tech's pleadings holistically, one thing that's apparent is that New Tech alleged causes of action that include causes of action based on the defendant's failure to do things, failure to exercise reasonable care, failure to supervise, failure to mitigate the harm that resulted from the particular actions that form part of the basis for the lawsuit. A failure to do something is not a communication, and therefore falls outside the scope of the Tcpa. The defendants here themselves segregated between the protected activity and the unprotected activity. It was the defendant's position, both in the trial court below and here on appeal, that Mr. Murphy, Mr. Nostein, and Mr. Kelly never engaged in any Tcpa protected act of communication. Therefore, New Tech's claims against those defendants necessarily were for their failure to act and not for anything that they said. Thus, those defendants cannot sustain and have not sustained their burden of proving that the Tcpa applies to New Tech's claims based upon their exercise of a Tcpa protected act. Even as to Mr. Hentos, 4th defendant, Mr. Hentos's conduct in disclosing Ms. Goines' confidential list of completion supervisors to Mr. Bercier's counsel in the underlying FLSA action was not Mr. Hentos's protected act under the Tcpa. And here the recent opinion in Finero-Lugo is very instructive. That's a case out of the Austin Court of Appeals just last year. The Austin Court of Appeals ruled in that case that the Tcpa did not apply to causes of action based upon a defendant's filing of an immigration application because the contents of that immigration application were not the defendant's communications, but rather the plaintiff's communications. Here too, the harm to New Tech arises out of the disclosure of Ms. Goines' confidential list, which was New Tech's communication, not Mr. Hentos's communication.
Well, here, your allegation or the claim in the Finero-Lugo case was that the communications by the lawyer were not the lawyer's communications, but rather the client's communications. He was acting on behalf of the client. It was the client's communication. But here you are disclaiming that communication. You're arguing that that communication was sent without authorization. So how could that be your communication?
The list itself was certainly Ms. Winstead's communication, and that was Newtek's communication, not Mr. Hintos's. But even with respect to Mr. Hintos's act, the fact that it was not authorized doesn't make it any less an agent's unauthorized representation on behalf of the principal. It doesn't vest itself with anything less than the representational character that it had when Mr. Hintos sent the communication purporting to act on behalf of Newtek, even though that particular action went beyond the scope of the authority that he possessed. Regardless, the evidence that Newtek presented to the trial court was clear and specific evidence of a claim of legal malpractice. The defendants challenged only two elements of a legal malpractice claim, the causation and damages elements. And principally, the defendants challenged the merits of the declaration that Newtek's expert, Ms. Annette Idowski, offered on behalf of Newtek in response to the Tcpa motion. Defendants claim that Ms. Idowski's declaration is conclusory. The relevant case here is the Texas Supreme Court opinion in Starboard. And as the Texas Supreme Court...
Well, let me ask you a threshold predicate question. Do you agree that if the trial court's evidentiary rulings were correct, let's just assume hypothetically, if they were correct, do you agree that in that case you would not have made out a prima facie case?
Well, it's clear that the trial court struck the affidavits of both Ms. Idowski and Mr. O'Neill.
Well, portions thereof.
Portions thereof. I would argue that the portions that were not struck were independently sufficient to sustain the causation and damages elements. And I do recognize that the first step on the prima facie case issue is going to be to address the specific arguments that the defendants offered in response to Ms. Idowski's declaration. They argue principally and foremost that Ms. Idowski's declaration is conclusory. But as the Texas Supreme Court noted in Starwood, an affidavit is not conclusory if it's based on facts that are demonstrable and reasonable, which actually support it. And here, Ms. Idowski's declaration rests on 5 clearly demonstrable and reasonable facts that support her opinion. First, the FLSA is an opt-in type of class, not an opt-out type of class that we're used to under Rule 23 of the Federal Rules of Civil Procedure. Number 2, the notice that a federal court offers under the FLSA is only directed to those employees who are similarly situated to the named plaintiff. Number 3, all parties, including Mr. Percier's counsel as well as the defendants themselves, recognized and acknowledged that notice should only go to drilling contractors, not drilling supervisors, not completion supervisors. Number 4, prior to the date that Mr. Pintos sent the list of both drilling supervisors and completion supervisors, no completion supervisors had pursued an FLSA claim against Newtek. Number 5, after the list was provided, the same lawyers who received the list, Mr. Percier's counsel, then pursued FLSA arbitrations on behalf of 3 completion supervisors. Notably, Ms. Idowski is not just an expert that was brought in to testify on cold, hard facts that the expert herself had to dig up. Ms. Idowski is a seasoned FLSA litigator She is the counsel whom Newtek hired to replace the defendants in defending against the FLSA claims. So based on her experience, as well as those 5 demonstrable reasonable facts, Ms. Idowski concluded that it was more likely than not that no completion supervisors would have pursued a claim against Newtek but for the improper disclosure of that confidential list. That is sufficient under Starwood for Ms. Idowski's declaration not to be conclusory. As to damages, the defendants protest that Ms. Idowski should have gone through a lodestar analysis to prove up attorney's fees damages. They cite no case supporting the proposition that a plaintiff must prove its damages with that level of specificity at the TCPA stage of proceedings. To the contrary, the Texas Supreme Court in S&S Emergency said that all that's necessary at the TCPA stage is for a plaintiff to offer some evidence showing a reasonable likelihood that the plaintiff would have some damages. And Ms. Idowski's opinion that the Newtek folks suffered at least $400,000 in.
And just to clarify that, so the position at the prima facie stage is just that the damages are limited to the amount that Newtek would have to pay out for these other claims that weren't included in the class.
Yeah, Newtek is seeking to recover its out-of-pocket damages for its attorney's fees in defending those claims.
But presumably those individuals may have had a claim otherwise, I mean, because they Newtek settled with them or arbitrated with them. Is that correct?
Because it's in arbitration, the amounts at issue are confidential, but regardless, the damages testimony before this court in the record would be the out-of-pocket damages for the attorney's fees. For
the attorney's fees for defending against those claims. Okay.
That's correct.
Thank you.
Newtek respectfully asks the court to reverse the judgment of the trial court. Thank you.
Good afternoon. May it please the court. Jeff Hilberg here on behalf of the appellees. I represent 4 of them. Carrie Notestein, Connor Kelly, Brian Hentos, and Terry Murphy. We're here today because the trial court below properly granted the motion to dismiss under the TCPA. We've got 3 issues before the court. One is TCPA applies, and it applies to all 4. Second, the commercial speech exception does not apply. And then third, with respect to the clear and specific evidence, they failed to meet their burden. And let me address those one at a time. First, with respect to the TCPA, it's important to note that I just heard counsel say that the harm to Newtek arises out of the disclosure of the list to opposing counsel. Now, the point of beginning for this analysis is under Hirsch v. Tatum. And under Hirsch v. Tatum, you look at the pleadings. What did they plead? And another little subtle difference here, when you look at the second amended petition and the third amended petition. Second amended petition, it's at Clerk's Record 21. Third amended petition at Clerk's Record 998. I point out that the third amended petition was filed on the same day as the hearing on the TCPA. But under both of them, in the record sites I just provided to the court, it's within that document. In both of them, they say defendants, plural, improperly sent this list over. So when the court's doing the analysis, you start with what was pled, not what ultimately came back. Because in Hirsch, the court found that you can deny that you ever even made those communications, and the TCPA still applies because you look at what was pled, not what was answered or denied. So under that analysis, you look at their pleading, and they allege that all 4 defendants made the statement. Then you go to, even though we denied, the Hirsch analysis still applies. New Tech now wants to argue, well, because they denied 3 of the defendants, and in particular it's Notestein, Kelly, and Murphy, because those 3 defendants denied, we're going to accept that, and now we are going to abandon our our claims with respect to that, but you can't do that. And that's the equivalent, and this court, different panel in 2018 in Abeta-Cola addressed that very issue, which is you can't non-suit a claim and try to abandon those claims to avoid the applicability of the TCPA. So with respect to the pleadings, the court looks to the pleadings first to see if it applies. Here, they allege that all defendants made these claims. They don't get to simply abandon it and say, oh, never mind, I want a mulligan. TCPA doesn't apply. That's not how it works, and Abeta-Cola supports that position.
Abeta-Cola was decided under the old statute, though.
It was, but it stands for the proposition that if you non-suit, you can't avoid a TCPA motion because of a non-suit, because a TCPA motion allows for dismissal with prejudice. So even though it applied under the old statute, that concept would still apply, because even under the new statute, you still have the right to dismissal with prejudice. So I would argue that Abeta-Cola still applies here. Now, with respect to does it apply to a legal malpractice claim? We start with Youngkin. Youngkin says, yes, the TCPA applies to statements made by lawyers on behalf of a client. Full stop. That's Youngkin, 2018, Texas Supreme Court. It also had a subtext of it's not limited to just constitutional First Amendment issues. It applies to all protected speech as defined in the statute. We cite Brown v. Sims. It's an old statute. It applies under the old statute. It also found that non-communication would apply, and we all know that's I don't believe that's the case anymore. We've got White Nile, we've got a bunch of other cases that say it only applies to active communications, not omissions, but we don't have that here. What's alleged is the act of transmitting data, so those cases don't apply in this situation. But the important thing about the Brown-Sims case is it discusses how there is no exception to the TCPA for legal malpractice. That's why I raise it here. There's no exception. There's no carve out. Legislature could have carved out legal mal claims. They didn't do it.
Well, how do you deal with Venero-Lugo?
Well, if you look at Venero-Lugo, that court expressly stated that its analysis was based upon cases that do not involve lawyers' communications in judicial proceedings. Venero was not a Texas lawyer, so in that case they discussed Venero wasn't a Texas lawyer, so we're not going to apply those cases, and instead we're going to apply the line of cases that say a party cannot rely on the statement of another party to invoke the TCPA. So therefore, even by its own terms, Venero-Lugo wouldn't apply because we're dealing with Texas licensed lawyers in this case who are representing parties in the proceeding. They also cited Cantrell in one of their supplement from last week, and again, Cantrell doesn't apply. It's a brand new, maybe a week old case out of Waco. Cantrell wouldn't apply because in that case, the movement expressly said in his motion that he was presenting this on behalf of his client. Let's see. He argued that the communications were in furtherance of his client's right to petition, not his own. That's not what we have here. So because of that statement, and when you read the case, it appears that the Waco court was addressing the specifics in the petition or in the motion. And it likewise applied non-reliance on another party's statement rule in that case. So I believe both Venero-Lugo and Cantrell are distinguishable here. But back to another case that's fairly new, it's the Winstead USA lending case. And it has several important impacts in this case, but one of which is it again held that the TCPA applies to claims based on filings a lawyer makes on behalf of his clients. We're going to talk about that Winstead again when we get to the commercial speech. But, and Justice Wilson, you raised a good point, which is New Tech needs to pick a lane, which is either the statement was authorized or it wasn't. And if it wasn't authorized, then the statements, the transmittal of the information, the alleged transmittal of the information, would be on their behalf. And here, we've got a long line of cases that say the TCPA applies, but the point is, if it wasn't authorized, it wasn't their statement. So they can't say, gotcha, TCPA doesn't apply. But in all events, we would argue that the TCPA does apply in this situation because we have active communications made in connection with the claims are for damages based on, I know we struck related to in the amendment, but based on the statements made as alleged by the defendants in connection with a judicial proceeding. Therefore, it falls squarely within the TCPA. Moving on to the commercial speech exception, in the trial court below and in our briefing, we addressed the second 2 points. The second is, did the statement or conduct at issue arise out of a commercial transaction? This brings us back to Winstead versus USA Lending, where in that case, it was a motion for default judgment that allegedly Winstead did not properly present and get their damages. Court of Appeals, Tyler, said TCPA applies, and they expressly said that wasn't the filing of a default judgment is not a, quote, commercial transaction. Just like here, we are in litigation. It's not a commercial transaction between anyone in this proceeding. So element 3 of Castleman doesn't apply. Likewise, element 4 of Castleman doesn't apply because the intended audience of the statement or conduct was an actual potential customer or defendants for the kind of goods or services defendants provide. Now, here, the communication upon which they claim their damages was a communication to opposing counsel. And they try to pivot a little bit and talk about, well, it was a communication to New Tech, but none of their damages are flowing. They don't allege any damages flowing from the communication to New Tech. When you read the brief, it says, oh no, the communication was to us, New Tech. No, that's not where their damages arise from. Their claim for damages arise from communications to plaintiff's counsel, who obviously is not a actual prospective customer of these 4 individual lawyers. So we would argue that the commercial speech exception would not apply in this situation. Now, getting to the third point that I want to raise, which is they fail to present clear and specific evidence of damages. And counsel said we're only arguing causation and breach. That's not the case.
I think you said causation and damages.
Causation and damages, I apologize. As to breach, as to Notestein, Kelly, and Murphy, there's no breach because there is no evidence that any one of those 3 actually conveyed the information. It was only Hentos who conveyed the information.
So with respect to whether the TCPA applies, you say the allegation is they did make a communication, but with respect to prima facie case, you then flip it and say they didn't make a communication.
That is correct, because when you go back to Hirsch v. Tatum, the point of beginning is, what did they allege? And just like in Hirsch v. Tatum, that was the same situation where they alleged that, I can't remember the, Tatum published an article, Tatum denied ever publishing the article. They failed to prove the elements, and in fact the court actually killed it on no extreme and outrageous conduct for the intentional infliction of emotional stress claim. But the point is, that's how the TCPA works. So they alleged, they failed to prove, and therefore, as to Notestein, Kelly, and Murphy, they don't even have evidence of breach, let alone causation and damages. Then when you get to Hentos, then you have the purported Nadolsky affidavit, and the key case that we rely on, and actually she cites in her affidavit, the Rogers v. Zanetti case. And in that case, the court struck the affidavits because they were conclusory, speculative, and improperly stacked inferences. And we would contend that that's exactly what happened here. Winstead PC, circling back, also addresses the improper stacking of inferences in dealing with expert affidavits.
Well, how do you deal with Mr. Keeling's argument where he says there were 5 facts, 5 pieces of foundation upon which she relies, and therefore it was, and I think I've written it down right, quote, more likely than not, close quote, that the only way that the underlying plaintiffs became aware of these 3 completion consultants was because of this communication, and under Starwood that's sufficient. How do you respond to that?
Okay, I respond to it this way. When you look at the Rogers v. Zanetti, what were those affidavits? And in those affidavits, it was Pete Marcados and Chris Kalis who opined that essentially it was, they opined, and they were counsel in the underlying case as well. Chris Kalis was counsel in the underlying Anderson case. It's laid out in the opinion. And what he said was, had Chuck Perry designated a rebuttal expert, the jury would have awarded less damages. And the Supreme Court went through that whole analysis and basically said, no, because you have improper stacking of inferences, and it's distinguishable from the Starwood case because that was a simple concept. And in Starwood, the affidavit, and I know I'm out of time, but
no, please continue.
In Starwood, the affidavit said the airplanes were seized because the notice wasn't sent, and in my experience, having done 3 or 4 of these, the DEA would have yielded if you had sent notice. So there's one step there. Here, you have Ms. Adolsky stacking inferences on inferences, which is plaintiffs would not have known about the FLSA litigation but for the defendant's production of the list. How could she possibly know? She never interviewed, she never spoke with opposing counsel, and while she acknowledges opposing counsel knew about these completion lists, she says that it was the threat of filing a separate lawsuit with simple posturing. How could she possibly know that? And as the Supreme Court said in Rogers, it's Ipsy Dixit. Just because you can say it doesn't make it so. Those are my words, not the Supreme Court's. They use, take my word for it, I know. But the point in all of this is the trial court properly struck Ms. Adolsky's declaration, and therefore they failed to meet their burden. Unless the panel has any questions, I'll take this.
All right, thank you, counsel.
Thank you.
Thank you. I'm going to make 3 points, maybe 4. First, on Finero-Lugo, I think counsel tries to distinguish Finero-Lugo in a step that goes way too far from what the opinion actually says. What Finero-Lugo does is it distinguishes between a lawyer's statements in the lawyer's representative capacity and a lawyer's statements in a non-representative capacity. It's significant that in Finero-Lugo, the court cites Winstead versus Moore, not Winstead versus USA Lending. There are a couple of Winstead cases, one out of Dallas and one out of Tyler. So in the Dallas case, which is currently pending in front of the Texas Supreme Court, briefs have been requested on the merits. The issue in that case was whether a lawyer's statements to the lawyer's client that turned out to be false and negligent, whether those privileged communications can afford the basis for TCPA dismissal. And the Dallas court in that Winstead case held, well, those statements are the lawyer's statements because the lawyer is speaking to the lawyer's client. But when the lawyer is communicating on behalf of his client, that's the situation that was addressed in the other Dallas case that we cited, the Snell case. That's also Finera-Lugo, that's also Cantrell, and that's this case. The communications at issue from Mr. Hintos were communications to opposing counsel in an underlying matter in which Mr. Hintos was acting on behalf of NewTek. Under Texas agency law, that makes those communications NewTek's communications, not Mr. Hintos's. Number two, Abaticola was a related to case. Abaticola from this court explicitly reached its result based upon the language in the old statute. The new statute applies in this case, and the new statute explicitly requires that the cause of action be based upon or in response to that movement's exercise of a protected act. And here the movements themselves have essentially argued themselves out from under the TCPA by admitting and confessing that they never made any protected act of communication. Number three.
Well, how do you deal with Mr. Helberg's argument that you look at the pleadings, the petitions, you look at Hirsch, and you pled all defendants, and that is, and I think in his words, full stop.
Hirsch absolutely says the first place you begin. In fact, Mr. Helberg said exactly that too. The first place you begin is the pleadings. But as the Texas Supreme Court later explained in Adams, you don't just look at pieces and portions of the pleading. You've got to look at the pleading holistically in light of Texas pleadings standards and the rule of liberal construction. And that makes sense because the TCPA doesn't impose any pleadings rules. And candidly, let's look at it under the context of this case. One thing you will most undoubtedly have already noticed, you will plumb the record and never find a copy of the actual communication from Mr. Hintos to opposing counsel. We asked for it. It was not produced before this case was dismissed under the TCPA. So from my client's perspective, they knew the four attorneys who were on the file. They filed the lawsuit under Texas liberal pleading standards and used the global term defendants. There was no special exception to that global term. They used the term defendants because at that point in time, it's unclear which defendant actually sent the communication. And again, that makes sense from a plaintiff's perspective. What do you do if you don't know? You plead it globally and use discovery to figure out who actually sent the communication. It doesn't change the fact that no one seriously thought that all four of the defendants jointly sent an email. It was clearly one of the defendants. And the pleadings on their face make clear that part of the allegation against the defendants was not just that the communication was sent, but also that the four lawyers representing NewTek failed to do things. They failed to exercise reasonable care to supervise the person who actually sent the list. They failed to mitigate the damages that result from the disclosure of confidential information. That forms part of the malpractice. Reviewing the pleadings holistically, those allegations can't be just fluffed away. They're part of the lawsuit, and those allegations don't come within the scope of the TCPA. NewTek respectfully asks the court to reverse the judgment of the trial court. Thank you so much.
NewTek versus Noticing that all is submitted, and we're adjourned. Thank you all very much.